All right, good morning. I'm Emily White. I lead the immigration attorney group at Reno. I have about 15 plus years practicing only in immigration law. It's what I love to do, and do the full range of immigration law from family-based, humanitarian, removal defense, through employment-based immigration, outstanding researchers, intercompany transferees. If it involves immigration law, I practice in that area.
I'm Olio. I been doing immigration law in some forms for about 40 years. And I've been with Reno for 24 years as a paralegal. So when I do most of the help out with most of the immigration, I don't do work on the asylum, that part of it usually. So stay away from that.
And
I'm really
Paula was originally an officer for immigration on the border. And sometimes she gets in that role. So hopefully today you'll get to see a little bit of that back and forth between us, where I've been the advocate in front of the court and she's been on the other side of it. And so we sort of get to play both sides of an issue. I think that adds some richness to the discussion about different options. So today, hi, welcome.
Thank you.
There are name tags right there, and they're pre-printed, or put your name on one. I hope we can just have a discussion as we go through the presentation. So ask your questions as they come, and then we have a lot to cover, but I hope we also leave enough time at the end that anything that you've been wanting to ask about immigration law is an open forum for that. So we're focused on how employers can grow the workforce through employment-sponsored immigration today, which means we're going to first go through the non-immigrant work visas that are most commonly utilized by employers in the United States. A non-immigrant work visa means that it is not a path to permanent residence. Someone may also be working on a path to permanent residence, but the work visa itself is for a temporary period of time to work in the United States. Then we will go through employment-based immigration, so how employers can apply for workers to obtain green cards or permanent resident status in the US. We'll touch upon different forms of work authorized foreign nationals that may apply for or be working for your companies. And what to look for in terms of those documents, how to properly complete an I-9, whether they need to be re-verified, and whether that type of immigration document means that they're likely to remain somewhat permanently in the US, or that you have an end date for this employee. So we'll touch on the new I-9 form also, and some of the changes there, including remote verification of workers if you're an E-Verify employer. So that's a lot of ground. I'll jump right in. I'm going to cover a few types of visas, and then Paula's really the H-1B expert, as well as employment-based green cards. And so she's going to get in depth on those, and that will be the majority of our time probably. So in terms of non-immigrant work visas, a lot of the folks that you might see in New Hampshire, especially in the summertime, who are non-US citizen workers, are on the J guest worker for cultural exchange program. So I know I encounter a lot of these workers like scooping ice cream at parlors, at restaurants on the seacoast, sometimes at some of the larger chains like McDonald's or Hilton. And they're often on this J guest worker for cultural exchange program, either for college students who are coming to do a summer exchange. So they must be between the ages of 18 and 30, and they're coming for a real short time, for the summer generally. Or those who are doing a trainee and internship program, often after completion of a degree, and they have an 18-month usually cap on their time in the United States. So those are options for employers who either have an influx of need in the summer to apply for J workers to be able to work at their places of employment. You can access that list, so you can actually see who's in New Hampshire working. Just Google it, J programs, New Hampshire. You'll see a lot really are at McDonald's up north, some on the seacoast at restaurants, and you can find all of that information. And then, you can also have someone for that 18-month period, but you'll work through a sponsor and you'll have to have a training plan for that individual. So how are they gonna get the knowledge of, let's say they're in hotel and restaurant management through your organization? What's the training plan gonna look like, with the acknowledgement that it's also a temporary position? Maybe you'll like that worker and be able to start a green card process for them. We'll talk about the green card processes, but initially, there's an agreement that that individual will go home because it is cultural exchange. That is the intention of it. Those two groups, though, for J's alone, totaled 130,000 work visas last year.
In a company, there's an umbrella company that handles, or there are many umbrella companies that handle the J's, so they have to pretty much take care of everything. They, they'll go through, review the requirements and everything. So the State Department has a list of accepted umbrella companies that handle that.
And like most of these visa types, there's some controversy about the J program, because those sponsoring agencies take a certain part of the payment, right? So you're paying through the agency, they're taking a cut, and the actual worker is getting a smaller amount of the amount that you paid. Temporary work visas also include the H-2B program and the H-2A program. The H-2B program are non-degreed workers generally. They are seasonal, temporary, or peak load workers. A lot of landscaping companies, sometimes construction, sometimes summer camps, any industry that needs more workers for a 9-month or less period of time in the year can apply for these types of visas. However, they're lottery-based. It's divided into 2 6-month periods. There are 66,000 available for new workers. The way that the program is administered, generally, it would make most economic sense to be applying for several workers at a time in terms of the recruitment process, the state workforce order that has to be posted. It's generally not worthwhile to do it for a single employee. Generally, it's 5, 15 or larger in terms of the numbers that people apply for those workers for. Given the lottery nature of it, there's a significant drawback. You do all this work, you invest all the effort, money, and time, and then you wait and see if your number is pulled. And then you often get notification very close to when the individual will start. Again, there are agencies that do this, and there are immigration firms also that specialize in this type of temporary seasonal peak load worker visa. Again, there's about 130,000 a year, including those who are chosen in the lottery and then the returning worker provision. So not huge numbers considering that that's nationwide. The H-2A program is a temporary worker limited just to agriculture. So mostly harvesting crops, preparing soil for crops. Some work also involved in like hog farming, cattle ranching, if it's seasonal. And those jobs generally are staffed through using licensed farm labor contractors. So if a farm were to need those workers, they work with these farm labor contractors, U.S. Department of State and USCIS. I think that's it on the temporary H visas. Are there questions about those before we jump into professional H-1B workers?
Oh, how long are they given? They can come in for a number of years, right? On the returning H-2B?
Yes, but each year they decide whether they're going to authorize the returning worker provisions, which they have historically, but everyone sort of waits each year to, are that returning worker provisions going to be authorized again?
So technically an employer could get the same person back.
Yes. Yes, so once selected in the lottery, there is a good chance, historically, based on what's happened, that that individual can keep coming back for multiple years.
Okay, so for the professional part of it, a lot of the employers find students who have been working here in the US on a student visa. They've received their degree and they have what's called OPT, which is optional practical training. That's issued for 1 year. If it's in a STEM program, they can get an extension of 2 years if the employer is E-Verify. So you can actually have them working for you for up to 3 years without having to really start any non-immigrant process. However, the next stage for the students is to get an H-1B. And the H-1B has a lottery system like the H-2Bs, but there are 85,000 visas available, 65,000 for people who have bachelor's, and 20,000, additional 20,000 for a master's program. So when we're in the lottery season right now, the lottery ends Friday at noon, and it has been open since March 6th. So we put, the employers have worked with us, we get them into the system, and then the lottery will run and we'll have the lottery by March 31st, who has been selected. Last year, there were 400 and some thousand applicants into the lottery for 85,000 positions or opening slots. But this year, they've changed the lottery a little. There was a lot of duplicate last year. So they're thinking it will be down to probably around 200 and some thousand for 85,000. So the odds aren't great. It's better than what it used to be. Because we used to have to prepare all the petitions and then submit them and see if they were selected. Now we just electronically submit them. It's a $10 fee this year. Next year it goes up to $215 and to go into the lottery. So we'll see. Traditionally, we are fairly lucky. Last year we had 7. I had 13. It'll probably be a year where I don't have it. So, but we'll see how that goes. So once they're selected, they have to make sure that they meet the qualifications of an H-1B. And that is, they have to be working in a specialty occupation. And the definition of a specialty occupation for immigration purposes is one that requires a minimum of a bachelor's degree. And so we'll put the petitions together, make sure the job description meets the requirements. You have to be careful sometimes with the job description, definition, and the requirements of that position. Another requirement for the H is that the employer pay the prevailing wage. And that is determined by the OES, there's the OES library, which is online, and we can figure out how much they're supposed to be paid in that geographical area in this occupation. So we get all that filed, and then they have 3 years, and we can extend it for another 3 years for a total of 6 years on the H-1B. So if you use the OPT time, you can have 1 to 2, 3 years on OPT, another 6 years. So you could have 9 years of someone working for you as a non-immigrant. We do recommend that we start the green card process before the end of the 6 years though, and I'll get into that. Touching briefly, there's also H-1B1s, which is for treaty, they're under a treaty, and that's with people from Singapore and Chile. And they never use up their allotted amount. So if you have someone from those countries, that's great. Also, there is the E3, which are people from Australia. And then there is the TN for North America, it's Trade North America for Canadian and Mexicans. And go ahead.
I was just going to say, importantly about the H-1B also is if someone applies for a position and has already been counted towards the cap, so they have an H-1B visa and they won it in the lottery previously, an employer would still need to file a new H-1B petition for them to work for a new employer, but they would no longer have to go through that lottery system. So once someone has been counted in that lottery, has an H-1B, they can change employers. So if someone comes to you and has an H-1B already in hand and was counted towards the cap, you know that so long as your position qualifies for an H-1B otherwise, you don't have that lottery aspect of applying for them.
Which is always a good thing when it comes to a green card too, because it gives them experience. The TN, a little more, is you can do it at the border. It's the most cost-effective situation, but the occupation has to be on the TN list. It just can't be any occupation. So there's accountants and science and what are some of the other ones? The engineers. The good thing about the TN, if you're working for technologists and technicians, they don't have to have a degree, a bachelor's degree, if they're working in support of an engineer. So if you had an engineering technician and that worked in support of an engineer, you could bring them in under the TN if they had an associate's degree, or sometimes in Canada, there's a 3-year degree that isn't necessarily equivalent to our bachelor's degree. So you can bring those people in that occupation.
It's a very flexible and fast application process too. It's fastest for Canadians, but it's still very fast for Mexicans. Canadians can just apply at the border, but Mexicans have to go to their consulate. But I'd still say in a matter of weeks from hire, you can have an employee in the US. Sorry.
Is the first thing you need to do as an employer is to register with the Department of Labor?
No, not necessarily. The good thing about the TN is you don't have to sign documents saying that you're going to be paying the prevailing wage. You just have to provide what the salary is going to be. So that's an advantage over the H-1B. Well, the H-1B, you do have to document that you're going to keep paying the prevailing wage. In the H-1B, you do have to file a form with the Labor Department. It's called an LCA, Labor Condition Application. And that's the first step of the H-1B, yes. But it doesn't.
Only for the H-1B.
Only for the H-1B. And those wages are, as I said, specific to that location. If they're working remotely, which they can do, and immigration is getting on board with remote work, that you have to have the wage for the person's remote location and for the head office. Yeah.
Okay, so jumping into the last two of the non-immigrant work visa types that we'll cover are E's and L's. So E's are visas available for treaty trader investors. So there's a list of countries with whom we have treaties. And then if an individual is either starting a new business in the US and from a treaty in country, they can demonstrate that they have made a sufficient investment in the United States to start that business and apply for these e-visas. Alternatively, if there is a company that's already established that's invested the sufficient threshold, which there's not like a bar, it sort of depends what's the industry and whether that investment is sufficient into the United States, then they can transfer employees that are either executives or managers or have specialized knowledge into the US to help run it. So sometimes those are international companies who have a branch abroad and a branch in New Hampshire. And sometimes those are just New Hampshire companies that are owned by, for example, German nationals. And so they're transferring other German employees into the United States to help run it. And then L, visas are for intercompany transferees. So those are really for a company that has branches abroad, branches in the US, and they want to transfer people who have worked abroad for one of the last 3 years into the US. Again, either in a managerial position or a specialized knowledge field. A bachelor's degree isn't required, but you do need to demonstrate that the role of the person is needed in either to manage or because they have specialized knowledge of the company. So that's generally, there are some other types of work visas, but that really covers the vast majority of employer sponsored work visas, you'll find people in the US who have employment authorization under many other categories, and we'll talk about that a little bit later, but where the employer is involved in sponsoring the worker, that's pretty much the alphabet soup.
And the H-1B is the main visa that's used most often for employers. It flows well from the student who's been here. They hire them on the OPT, they like them, they want to keep them, so they file the H-1B for them to move forward. So, and the TN, it's only $57 for filing fee, which is best deal in town.
Yep.
So. Okay.
So what if, like, you don't want to have a 3-year visa or go through these lottery systems? You know someone, maybe they're abroad, maybe they're here, and I want to, as an employer, sponsor them for their green card and then have them work for me for here on out.
Which you can do, it just is gonna take a long time. Right now, typically it takes about 2 years, 2.5. It's getting longer as we go. It didn't used to be this long. You used to be able to do it in about a year. But the process now has just increased so much that it takes a good 2.5 years to get someone here. They can come directly. They don't have to have worked for you previously. It's a future position when you file these forms, so they can be overseas and you can bring them in the position as long as they meet the requirements. So there's 3 categories for employment base, and they're EB1, EB2, and EB3.
In the packets of information is the visa bulletin. And so it breaks down both the family-based categories, but also the employment-based preference categories. So as Paul is going through this, you can see the charts starting on page 4 for employment-based preference categories. And so when she talks about EB1, 2, and 3, she's talking about the first, second, and third on these charts.
And as you see, it's broken down into different countries, and India is the most backlog country. And the EB1, I'll just mention, is for outstanding researchers, extraordinary ability, or people of international business. It kind of goes along with the L1 that we mentioned earlier. You don't have to become an L1 first, you could come directly in, and that's probably only a year process as opposed to a 2-year process. So that's the EB1, and as you see under all countries, that's current. A few months ago, that was not current. There was a backlog even there.
This is the March visa bulletin. April's already out, but each month a new visa bulletin comes out and these numbers change.
Right, and sometimes they move forward and sometimes they move backwards. So within EB2, the requirement of the EB2 is that the occupation requires a minimum of a master's or higher. And it's the occupation, it's not necessarily what the employee has that you want to sponsor. It's what the occupation in your company typically requires. So that's the EB2, the EB3, it has to be a minimum of a bachelor's or higher. Now, your employee may have a master's, but if the job requires a bachelor's, it's an EB3. And a lot of employees try to get you to move it around. And say, but I have a master's, so I should be an EB2. So, but no, they're an EB3. And then other workers. Other workers we've done a few of these lately where they are coming in that there is not a degree required to do the job. But we can get them in under this. When we started doing one a couple of years ago, it was current and there wasn't a backlog. And then in the last 2 years, it's backlogged 4 years now. So it's timing. We can't control this. And so we start at one point with the process and then we go on and make adjustments, hopefully keep them in status or figure out what the situation is. The employer needs to decide if they want to keep them, if there's going to be a break in time where they can't work. Sometimes, mostly with the other workers.
And often with other workers, again, it's a time where there's an opportunity to do more than one worker at a time. So we're working on one group of 10 workers right now who are coming back and forth on the the H-2B program as seasonal workers, but they could really work year round. And so we're doing a group of 10 workers for this particular company of, unskilled workers, other workers who are, very much skilled. They just don't have a bachelor's degree. And they're needed to be year round. So the H-2B limitations are just problematic, but there'll be probably a 3-4 year wait.
And part of the process for getting an EB2 and an EB3 is a 3-step process. You have to go through what's called the PERM application, which involves getting a prevailing wage determination from the Department of Labor that currently is taking at least 6 to 7 months. And then we do a recruitment. For a professional recruitment, it involves 2 Sunday ads, a job order, a notice of filing posted on a bulletin board, and 3 additional options such as Indeed, employer website, employer referral program, on-campus recruiting, things like that. And we go through all of that. Jobs have to be up 30 days and down 30 days. And then if there are no applicants, qualified applicants, then we can go ahead and file the PERM. Right now, the PERM is taking over a year once it's filed. So right there, you have a 1.5 years and you're not even quite done, or you're done with part 1. The last one we received took 1 year and 4 days. And this is the first time it's ever taken a year. Previously it's been, at one point it was even 5 months. So once the PERM is certified, you then file an immigrant petition. You can do premium processing for that. So that can take 2 weeks. Normal processing is about 8 months. And that would depend on if it would be a business decision, whether you do premium processing or not. If you have someone from India and their priority date isn't coming current the next 14 years, then there's no real reason to do the premium processing. But if you have someone else who's not from India, say from Canada, you could do premium processing. And then the final step is adjustment of status. Sometimes you can do the second and third step together if the priority date is current. So, the I-140 can be quick. The 485 still takes, I don't know, it's ranging 5 to 10 months.
And so the 485 is the application for the green card. It's I-485 application to adjust status to permanent residence. So permanent residence and green card are terms that can be used interchangeably. And if someone is applying either through employment-based or family-based immigration, that last step is their actual 485 application for the green card. It's interesting that the individual isn't fully vetted until that last step in the process. So for these employment-based processes that Paula just went over, even for all of the non-immigrant visas that we talked about, there's a certain background check that happens, but all the legal questions about, have you ever been a drug trafficker? Have you ever persecuted another person? Are you coming to the US to practice polygamy? Are you a habitual drunkard? I mean, they're just pages and pages of questions. The individuals have often been in the US for, if you look at some of these backlogs, a decade. They're not asked until this last stage in the process. So part of what should happen if you're hiring workers who need to go through these processes is have a way to ask those questions early on in the process, because you can be far into the investment in this employee and then find out that they have to answer yes to some of these questions that is going to prevent them from getting a green card. And everyone answers the same questions, whether they're an EB1, outstanding researcher, or they're in the other worker category, or they're going through family-based. And unfortunately, frequently, there are inadmissibility issues, meaning they're not allowed to be admitted to the US, that don't arise until this final step in the process. But once that 485 is granted, the individual is a permanent resident which means that they can reside permanently in the US, but must preserve their permanent residence. They're not a citizen yet. And so if you have a permanent resident worker, they can't leave the US for significant periods of time without getting advance permission to do so. And they also are subject to deportation from the US if they get involved in criminal activity or fraudulent activity. All sorts of grounds can make that person removable from the United States. So I think that distinction between permanent resident and US citizen is still critical. And then most individuals are eligible to apply for US citizenship 5 years after they were admitted as a permanent resident.
So we're, as an example of the time frame. So someone from India in an EB2 position right now, March 2012, I would have filed that perm application for them in March 2012. They are now eligible to file the 485, which is going to take another 10 months possibly. And then they have to wait another 5 years to become a US citizen. So it's a more than 20-year process for some of them.
Particularly from India and China. The rest of the world is
It's not so bad.
and also mostly the same priority date regardless of professional background. So whether they have a master's degree or higher, or whether they're in the other worker category, there's only a 2-year difference. It's still significant.
Well, I just want to ask why. Is that a staffing issue? Do they keep adding, does Homeland Security keep
No,
adding layers of?
Well, so for why the processing times have started to take so much longer in terms of like prevailing wage determinations, that part in the process is a staffing issue at Homeland Security. For the visa backlogs, that's based on the system of allotment of visas. There's only so many visas available in each category per year. And once those visas are used, they roll over till the next year. And so unless we change what that allotment of visas are, so only X number of people are going to be allowed to be admitted from China in EB2 per year. And so that part is regardless of staffing.
Are there lobbying groups working to change those numbers?
There's a lot of lobbying efforts for changes in immigration. Like we do a lot of Conrad 30 waivers for physicians. There's also a need for more physicians in the US, and there's only 30 available per state, right? But I think all of those lobbying efforts are to lay groundwork for something that may happen years from now, but it's not going to be this year or next.
So is somebody, when they're in the perm status, they're grounded for, you had said like, unless they give advance permission to leave? So like if somebody is from Canada, for example, perm, what are like, I guess, grounds for them to be able to leave? Like, why are they?
So a permanent resident can travel freely. They just can't abandon their permanent resident status by no longer permanently residing in the US. So if they're out of the US for more than 6 months, there's a presumption that they've given up their permanent residence in the US. So that's the risk. They don't have to provide generally a reason for traveling unless they're going to be outside of the US like more than 6 months, more than a year. Then they're going to ask for advance permission to reapply. So say me or my spouse has an opportunity abroad that we want to do for the year, but we intend to keep our residence here, and USCIS has advanced knowledge of that.
Thank you.
Do you think it's a good time to get into other types of work authorization? Okay. So you have applicants. Often you don't know what type of documents they're going to provide until they come in to complete their I-9. Not always true, but I imagine that you haven't always screened that appropriately so. And so they come in to complete their I-9 on their first day of employment. And they bring a work authorization document with them. So they just bring a card that says that they're authorized to work in the United States. There are obviously many different reasons that they could have an employment authorization card. And then that employment authorization card is gonna be valid for different periods of time. Some of them now are valid for 5 years, some of them are valid for 1 year, but so long as it's current at the time that it's presented to you, it's a valid authorization to work.
And some of those might be those F1 students on OPT, they'll have that valid, we call it an EAD card. That would have it, and then there's others that will also have it.
So I included a copy of the I-9, I'm sure you've all, many of you have seen it, in the packet. And so that individual is going to be checked on box 4 of section 1, who's a non-citizen authorized to work until X date, right? And so I just wanted to go through quickly why they might have that document and what it might tell you about how long they're gonna be able to work for you. Because if they come to you and you've already hired them and they show you a document that only shows that they're eligible to work for the next 6 months, what can you expect? And it really depends on the code on their card. So they may have a card that says C9 on the eligibility card. You don't have to memorize this, except that these codes are all available online. But that would indicate that they're applying for their permanent residence. So their application for their permanent residence is pending. They got work authorization while it's pending. It could be that they have a 99% chance of having that application approved, right? It could be that Paula's gotten them an H-1B every year for the last decade, and now finally she's applied for their permanent residence. And you know, they're changing jobs. We want to get into all of that, but they have work authorization and it's going to be approved, and probably that work authorization is even going to be extended. Or it could be that they have this work authorization based on an application for permanent residence that's has an underlying marriage that's an absolute fraud and is going to be denied in the next couple months, right?
All possible.
All possible. You just don't know. But that C9 is going to tell you they're applying for permanent residence and we're granted permission to work while it's pending. So those are individuals who have work authorization. Additionally, those who have been admitted as an asylee can get work authorization. They also have work authorization incident to status, meaning they don't need a work authorization card. They can show you that they've been admitted as an asylee. And an I-9 can be completed. There are very specific instructions for how to do that in the manual that goes with the I-9. DACA, so Deferred Action for Childhood Arrivals, the program for people who entered the United States before their 16th birthday and completed their high school education, or got a GED in the US or still in school. As Paula said, those on OPT, so they got a degree in the US and now they have some practical training. But all those work authorization documents have a limitation. Again, some are 5, some are eligible for renewal, some aren't. But they're authorized to work. And the important part about those classes is, one, maybe looking up what that class is to get some sort of sense. And then also noting that they will need to be re-verified on that I-9 at the time that their work authorization expires. And at that point, some people will come back with their green card. Some people will come back with proof that they renewed their work authorization. Even though they don't have a new card, they got an automatic extension. And other people will say, oh, I forgot to tell you I got my green card. Here's my green card. And then their I-9 will be updated.
And you no longer have to re-verify them once they have the green.
Yeah. We have done, or Paula has done actually, this presentation just on the Form I-9, because that's obviously such a big issue in itself, how to verify that employees are authorized to work in the United States, citizen, permanent resident, and those in an application process or on a non-immigrant visa. We did want to flag today that there obviously is a new form.
So you should be using this version only now, moving forward.
That seems that it's a longer form, but it's in theory anyway, a simplified form where they've just added 2 addendums instead of trying to get everything on one form. So there's the form and then there's a page that you could only use if you have a preparer and certification, translator certification. And then there are I really actually like this, that there's a separate re-verification and rehire form, because that was a lot to get into the bottom of one form, and then you were trying to get an addendum, filling out a whole new I-9. So I think this is a good development. And then there's also, and it's in your packet, I thought this was useful, the summary of changes to the form. It's just a one pager put out by USCIS about what they've tried to do, and it's a little bit about what the public policy rationale is behind the form. And then it's also clearly plugging E-Verify. I think the move is to try to get everyone to be E-Verify enrolled employers. For example, the OPT students who can just work in any field related to their field of study, so they can have, again, a degree in hotel and restaurant management, and they don't need to work in a position that requires a bachelor's degree. So they can work in any hotel in theory, right? And so they come and they work for a year. If they're also in a field, that's probably a poor example for somebody who would have a STEM extension. But if they have a STEM extension, they're an engineer and they're eligible for a STEM extension, you can only hire them for another 2 years if you're an E-Verify employer. So they're putting out lots of carrots, like you can only do this if you're an E-Verify employer. And that's true too about remote verification. So remote verification of workers on the I-9 can only happen for E-Verify employers. And I think there's going to be more and more of those. You get to do this thing that's more flexible and with the times, but only if you first enroll in E-Verify. And if ICE ever were to come out and do an audit of your I-9s and find that there were technical violations of the I-9s, then they would often say, we will reduce your fine by some significant percent if you enroll in E-Verify. So it's a frequent inducement vehicle for making changes.
Does anyone have any questions about the I-9? Any problems you're having with the I-9? Any issues you see?
Aren't there issues with the E-Verify process that are a little bit challenging and cause delays in hiring as well?
I really.
Yes, because if you put somebody through E-Verify and you get feedback that they're not authorized or this individual is not confirmed in E-Verify, then what do? Then you have to ask for different documentation or contest it through E-Verify, right? Also, you can't just, and this is, I think, a common mistake, is people think, oh, okay, I'll E-Verify my STEM OPT individuals. You have to E-Verify everyone across the company, so it has to be a change that happens for everyone going through.
Can't pick one, not none.
Can't pick one, right? In general, anything you do for the I-9, you have to do for everyone. You can't say, oh, okay, well, for my US citizen workers, I won't keep copies of their documents because I won't need them again. I'm clear that they're a US citizen. I saw the passport, but I will keep copies of my foreign national workers who I need to re-verify. I see that a lot on ICE audits. And it's well-intentioned. The thought was, I'm keeping this document because it expires and I want to have a way to trigger that it expired and I got a new copy, but that's a violation. You have to treat everyone obviously equally. So if you're going to keep documents of anyone's, keep documents of everyone's. And if you're going to use E-Verify for one person, you have to use E-Verify for everyone.
Another common issue we see is where list A document and a list C document are put down, and then that's over verified, and they can get you for discrimination on that. So if you have a passport or an EAD, those are all list A documents. Don't put down the social security card they give you also. So it's only the list A document. But it.
Because it's more.
Right, I do like the way, again, this form, I think, has a nice change with that heavy bar and the or being safe.
I have had people, I require a social security card as well, because I've had people lie on a social security number and actually not be able to file their.
And you,
taxes
as an
and-
employer on other employment documents, yes, you can do that.
So many people, I lost it. I don't know where it is. Well, it's free. Go down to the.
Yep.
The key there is, like Paul said, it's good like to have it somewhere else that it might be required, but on the I-9, you can't technically tell them which documents to provide. You can provide the list and say, you can provide this document or these documents, please come back with your documents. Very often, though, if somebody is going to do the B and C, they're mostly gonna bring in their driver's license and then they're gonna do the period. All right, so I mean, most people provide.
Sometimes they try to hide, like I use drivers. Sometimes they try to hide that they don't actually have a driver's license. It's red, not blue, you know? And
Yes,
so then I have to see all,
yes.
just not on the I-9, not
Well,
listed on the.
right, yeah, right, and well, and that's gonna be another issue that relates to work authorization too, is especially in New Hampshire, their driver's license is connected to their work authorization. So if their work authorization was only valid for a year, they only got a year driver's license, and then they're having a hard time getting renewals of that driver's license when their work authorization, maybe they have a valid basis even to renew it, but it's taking a long time to renew it. And the
Right.
DMV is saying, well, I can't give you a new license until you provide me proof that you're still work authorized. So those pieces often they do go hand in hand in New Hampshire, not in every state. And so that's also why you'll see people in New Hampshire who have driver's licenses from another state, is because each state has a different patchwork for how they do their driver's license relative to immigration forms. And sometimes the person has absolutely valid work authorization in New Hampshire, but they didn't want to deal with getting a driver's license every year. So instead, they got a 10-year driver's license out of Washington State or New Mexico or wherever will allow them to do that. So then you have a bit.
We do recommend that you do self audits of your I-9s every year enough. Just to make sure everything's in order, make a memo to the file saying that you did an audit on such and such a day. If ICE stops by, that way it shows good faith that you're trying to keep up with it. I mean, larger employers have a harder time with it. Smaller employers, it's fairly easy.
Again, make sure that in that process, all employees are treated equally, though. I mean, that's the balance with the I-9. So if you find that, you have issues with documents, if you find yourself saying, well, I know that person's a US citizen, so I'm not gonna ask for the document. But that person is a foreign national, so I will ask for the document. That's where you get in trouble. So if you find something's lacking, make sure you treat all employees the same and not discriminate based on their country of origin. If they were authorized to work at the outset when you completed it, then they need to be all treated equally going forward. Of course, that doesn't mean that you shouldn't re-verify those who have to be re-verified, and that is based on their limited work authorization.
Family?
Touch on family. Okay, we have 10 minutes left. I'll try to do 5 minutes of family-based and then just any free-for-all question. So the beginning of this visa bulletin are the family-based categories. There are immediate relatives that aren't on this visa bulletin. These are preference categories. So these are individuals subject to a line. An immediate relative is the spouse of a US citizen or the parent of a US citizen where the child is over 21. So for those individuals, they can be applied for directly for permanent residence without needing a priority date or to wait in line. These categories, so sons and daughters of US citizens, spouses and children of permanent residents, these are all individuals who are subject to these lines. And you'll see that the lines are different for family-based category than they were for employment. I mean, they're mostly the same, but there's some differences here. And then that the waiting times also are much different as well. So I think most notably now is the spouse of a permanent resident. That line used to be current, so that's F2A.
F2A.
So that line used to be just a couple months. So if you were a permanent resident and you applied for your spouse, you file the petition and you wait a couple months and then they could file their application for permanent residence, but now it's backlogged. So now it's back a couple years, that individual is gonna be waiting. And so whether they're waiting here in the US, because they have work authorization and are able to be here, or they might be waiting abroad for those years to come into the US. People talk about applying for siblings. That's an option, but look at how long these lines are. If you F4, if you applied for your sibling, in 2007, just right now, they might be able to file to get their permanent residence.
In Mexico, it's back to 2000.
Yeah, so a 20-some year wait if your if your sibling is Mexican and waiting for that permanent resident documentation. So we're waiting for that priority date to be current. So I would file for my sister who's from Mexico in 2000. And all this time, she would be waiting for that date to come current. And every month she might be checking this visa bulletin and waiting for that date. And when October 15th of 2000 comes current, she can ask to come as a permanent resident. And that would probably take about another year until she would get here. So there are long backlogs in many family-based categories, but spouses and parents are no line and they'll never be aligned. They're not subject to these allotments of visas.
And the process is similar. It's a two-step process. It's an I-130 immigrant petition and the adjustment of status, which if they're in the United States legally, then you can file both of those together. And it's currently taking, we've had some in 4 months lately, and we've had some that are a year. So again, it's a range, depends where they are in the country. Being federal, we do have clients all over the country. And each office throughout the country is a little different time frame for how long it takes. Somewhere in Los Angeles is obviously going to take a lot longer than here in New Hampshire.
If a family-based petition is filed here in New Hampshire, or even some employment-based petitions that I get interviews on, it's rare that we have interviews on employment-based petitions, but it's all in Bedford. It's a very nice, new, smallish USCIS office where a couple or an individual who's applying for a benefit go and have their case reviewed by an officer. If it's a family-based case, usually the only reason that they have somebody in for an interview is to determine whether this is a real marriage, or if the individual has a criminal background or something that needs to be talked about in their application for permanent residence. Like, it looks like you were denied for a visa 4 times. What's that about? Or I see you have 2 DUIs. Talk to me about that. How did that happen? Are you a danger here in the US driving, and how have you rectified it? So that's the lay of the land of employment-based and family-based at the very sort of surface level. Does anyone have questions about anything immigration related?
How long is a typical a visitation visa? So if you say you had a wife
Yeah.
overseas and you wanted her to come here as a visitor and not work
Yep.
And not
Okay.
stay.
and not stay and then you can file the,
So it depends on where they're from.
not that you have one.
Yeah. So there is a visa waiver available for individuals from some places in the world, mostly Europe, but there are other countries on that list where it's been determined that there's a very low chance that the individuals from those countries have overstayed their visa, and so they can come on this, called an ESTA, a waiver of a visitor. Just like there are countries where, as US citizens, you can go without a visa, and somewhere you need a visa.
And as of October, you're gonna need to start applying, US citizens need to start applying for visas to go to Europe. It's gonna be the same program, this ESTA program. And it'll be valid for 3 years, but you're gonna need it in addition to the passport.
So when do you start that?
They said, they're waiting till October to start it because they want to get the Olympics over with in Paris first.
The tie.
That was the tie.
Yeah.
And then they'll start it applying in October, and I think as of April, US citizens, April 2025, you'll need a visa to go to Europe.
And
It's through this ESTA program.
Okay.
And your passport needs to be valid for more than 3 years because the ESTA would be issued for 3 years. And it's similar to other countries coming this way. It's because we're requiring it of them, they're gonna require it of us.
And I didn't answer the term, but it would be generally valid for 6 months. If they have a tourist visa, B1, B2 visa. I'm always worried about a spouse. I know this is a hypothetical question, but coming from abroad, because on a tourist visa, they're really looking at both the issuance of the visa at the consulate abroad, and then when the person presents the visa to CBP, are you really coming temporarily to be a tourist or as a business visitor? Or are you gonna stay in the US? And so if you have family ties in the US, they're looking to, okay, well, are you just gonna come and get married and then try to do your green card process here? Are you gonna live with these individuals? It looks like actually all your family's here. Why are you gonna go home? So that's always the inquiry about tourist visas. Is this person really a tourist? Or are they trying to permanently come to the US? And so you'll see many people are denied tourist visas. It's very hard to get a tourist visa in some countries of the world. And then often people travel all the way to the port of entry and then they're turned around because they brought their cat. And the CBP officer says, I don't think the tourist would bring their cat, or whatever it is, right? Like that's always the conversation at the border is tell me how you're really coming temporarily.
So if you're a spur of the moment traveler, can you buy one or get one of these visas ahead of time and just keep it for the 3 years, that plan? Okay.
Right, that's the idea, and that your passport has to be valid beyond that 3-year period.
And how long does it typically take to get those visas?
I don't think we know yet because it hasn't started. But yeah, so I think for Europeans, getting the ESTA takes, it is pretty fast, it's like a week or so, I think. And then it's valid for, I thought it was 5 years for them, but maybe it's 3. I don't know, so.
Maybe that'll change because
Yeah.
usually we end up being reciprocal, whatever it is. But importantly, and I think this will probably be true for us, although I don't know all the logistics yet, is it's a visa waiver program. What I tell people is like you waived the requirement to get a visa, but you also then waived a lot of your rights. So people who come into the US on a visa waiver program, if something happens in the US and they're placed in removal proceedings, they don't have the right to have any review by an immigration judge of determinations because they waived that by traveling on visa waiver. So I'm interested to find out what we will waive by traveling on visa waivers that might otherwise be available if you traveled on a visa, because there's usually a difference in the process.
And you can still get a visa, once you get a visa, a visitor visa, it's usually valid for, it used to be 10 years, is it 5
Yes,
years?
10 years now.
10 years. And that gives you permission to apply for admission to the United States. It doesn't mean that you can come for that 10 years. It's just you can frequently apply for admission within that 10 years. Once you're admitted, you're given 6 months. You can extend that 6 months within the United States if needed, but you have to show how you're supporting yourself, the purpose of the trip, before they'll approve it. There's a B1 visa also, which is a visitor for business, and use the same type of visa because the visas are usually B1/B2. And those are for businessmen who come in for meetings, conferences. If they're selling international products, they cannot sell any product that's produced in the United States, but they could come in to be making sales calls to people of their product that was made in France. And that can be also. They can have guest speakers. You know what I didn't do? We talked about the lottery in the H-1B, but there's also cap exempt employers, and those cap exempt employers are universities or institutions of higher education, or employers that are affiliated with institution of higher education. And you don't have to do it once a year with the cap in the lottery for an H-1B. In those situations, you can do it at any time of the year.
How does it seem most of the restaurants and such right now have people from the Bahamas or from Jamaica?
Because that's it's their J programs, I imagine,
Or their H2Bs.
or their H2Bs.
Because they're
Yeah.
seasonal.
So there's and there's a sponsor organization probably that is staffing through those countries.
Okay.
A lot of the ski resorts use them too, this
Yeah.
time of year.
Even in Laconia, you know,
Yeah.
there's a lot of Bahamian.
Yep.
Yes.
Bahamas
Yep.
And then again, down on the seacoast too.
Yep. But a couple of years ago, those same agencies were using people from Moldova, right? Like I think the Lakes region had a lot of individuals from Moldova at any of the restaurants, ice cream parlors.
Especially because it's so seasonal there.
Right. Yep. And so that's really how the agency staff is where they're finding people.
Yep.
Who have a need. So, and those patterns often follow the economic circumstances in those countries where they come and work under those programs. The J workers usually make a bit less than the prevailing wage, so because the agency is taking a cut.
And sometimes housing has to be provided, and sometimes. it
Oh,
doesn't.
yes, yeah, even at apple orchards, I've talked to a
Yeah.
couple of those.
Oh, yeah.
owners, They have to provide everything.
Yeah,
That's the H2A. for the
Okay.
apple orchards.
yeah,
Okay.
that's our agricultural. Yeah, some of the big farms in the southern part of New Hampshire use that program, and they have housing as part of it.
One of the owners of the apple orchards was telling me though that he has to actually send back major reports of stuff of what these workers did or what they didn't do. And he was actually saying it's a lot of paperwork once you actually get them here
Yeah,
to validate why they were here.
yeah.
Okay.
Yeah.
So it's not just you get them here and they're, you know what I mean? They're here. You just still have a lot of paperwork afterwards to take care of.
Yeah, and I think there are many public policy issues coming into play, but one of them is that the programs are intended to ensure that there are workers available where needed without in any way undercutting the US wages or labor market. So that's the issue with the prevailing wage. And then for agricultural workers, there's a different wage, but it's I forget what it's actually called. It's something about adverse wage. What is that? I know the abbreviation, but it's the adverse effective wage rate. So they determine what can these individuals be paid. It's probably less than the prevailing wage, but that doesn't adversely affect the labor market rate for anyone else who wants to work at an apple orchard.
Right.
And so all of these reports are going back often to the Department of Labor. And then there's also making sure that there's not the worker exploitation that happened under like the Bracera program in the 80s, mostly California, where there was a lot of exploitation and workers who didn't get paid at all.
Naturalization, is that the easiest way in?
So naturalization is the last step, but you have to have gotten in as a permanent resident first. There is no naturalization that didn't either come from first being a permanent resident or was derived. So you're never actually applying. You just were a citizen based on virtue of your parents usually. And I think there's still a lot of confusion about who's a green card holder and who's naturalized. But generally the process is green card holder first for 5 years, except if married to a US citizen and living in marital union, and that's 3 years, and then an application for naturalization.
In your opinion, do employers need, just in general, to more actively just step into the whole? And they do, it's having to more actively step into the whole immigration process as a policy issue, if they're gonna grow their workforce. And really look at the global.
I think it depends on the area, the industry they're in. There will be some industries that don't need it at all. And others, they will, and I think it fluctuates also. A lot of it, I think, comes down to what the students are studying when they go to college these days. What they're not studying. Is that kind of blows over into who's gonna be able to be hired.
And I think professional associations is one place where that role of industries is getting increasingly involved, like Associated Landscape Contractors, hospital associations, right? Different industry groups saying we have across the country or in, 13 states, an extreme shortage of workers. And so we need an expansion of the H-2B program, for example. Or we need a non-temporary work visa and I think that's a ask that we don't have a solution for is those work visas for individuals who don't have a bachelor's degree are all temporary positions. There's obviously a need for a year-round visa for temporary workers. And that, I think professional associations have a big role in coming together and making those asks. And clearly, employers are utilizing these visas or we wouldn't be as oversubscribed as we are everywhere. But that's increasing those caps as well, given how many are entering these lotteries every year in excess of what's available.
The 60,000, 65,000, and 20,000 was allotted in 1991, I think it was, for the 65,000, and few years later, they added the 20,000. So it's been 30 plus years, and we still haven't changed the numbers. So.
And when we look at recruitments, because many of these require recruitments. And there's just so many recruitments we run where they have really posted advertisements everywhere for highly paid positions. And there's just no qualified US worker available for the position. So there is a real test the labor market in these. And often I see that labor market was tested and there's just not somebody in these positions.
Can you explain a little bit more the E-Verify? Is that only for immigration issues or is that for US citizens as well, like for checking backgrounds nationally? Like what is that?
Yep, so any employer can enroll in E-Verify. It seems as though ICE really would like everyone to enroll in E-Verify. And it's like an instant confirmation or not confirmation, as you were alluding to, that the individual has presented bona fide documents to work.
Okay, so it's not criminal, correct? It's not criminal
No.
connected.
No, and in a way, no, it doesn't do a background check, but for verifying that the individual is authorized to work.
Okay.
In a way, it does, I won't say it like prevents liability, but it's an additional argument. I did everything I could to ensure that I had an authorized workforce, including putting everyone through E-Verify.
Is there a cost involved with E-Verify?
I don't know the cost.
I don't think
that there's a
I don't think
cost.
so.
There is some training that you have to do and you have to have like administrators that put individuals through E-Verify, but then you'll know, like somebody gave you a social security number that doesn't correspond to this person's
Right, I
name.
feel like I'm the only employer that ever had that happen.
No,
Everybody I talked to was like, I've never had that happen.
no, for a while, they were sending out no match letters.
Yeah, and they've still
You didn't get that till you do your taxes,
Exactly.
April, a year later.
And then you couldn't really take action on it.
Yeah, it's gone.
Yeah.
You just get a little,
So this tells you right away that that social security number does not correspond to Emily White.
okay, E-Verify does.
E-Verify does. And sometimes it tells you that in error and then there's a process, but it seems like that's gotten better over time.
And that's also especially because people, multiple marriages, multiple name changes, stuff like that, maybe?
Right.
Okay.
Yep. But then E-Verify provides you the opportunity to demonstrate that you've done your due diligence to kind of rectify it. Okay, Emily White explains that it doesn't match because she's changed her name. And
Okay.
so that's the name now associated and you have a copy of that document.
Thank you.
Right, well, I think that's time. Our cards are in the pamphlets here, so if you have follow-up questions, feel free to send them. Thanks for coming, everyone. Get a nice eye.